Greetings, loved ones.
Everybody.
Good to see you. This is Equity Class number 6, if you can believe it. It is May 4th, 2024. So we have been posting some very thought-provoking questions on Telegram in as far as how the man and woman operates inside of equity. And it is very different than legal, as you know, loved ones. And this is not something that is taught in schools. This is actually not anything that is being taught anywhere that we know of other than here at Divergence. So we're going to start pulling this apart, breaking it up a little bit more so that you know how your affairs are going to be handled in equity. Before we do, though, we want to do just a few little housekeeping kind of cleanups here. As far as our class proceeding, it is still evolving, loved ones. The more that we do our paperwork, the more subclass members join our class proceeding, the more things that end up coming up. So one such thing was actually one thing that we released last week, which was the new edition of the thumbprint on the AAA, the space for the valuable consideration. And we actually had some teenagers join us this week. We are so excited to have them. We have a 15 and a 16-year-old start. And I tell you, brothers and sisters, when you hear young ones speaking to the AAA, when they're just muscling through all of these big words and they're speaking on why they're joining and no longer want to be an adverse possession of the person, it's just something that warms your heart. Not to mention when one of the little ones says that they actually want to be an equity master and a teacher and an ambassador so they can help other ones in need. So very heartwarming. However, that brought up another situation in as far as what happens when young people are added onto the program. So just one moment, please. Okay. Okay, our apologies on that. We just wanted to finish up on what happens when there are children between the ages of 7 and 14 or 14 and 21 that want to add themselves to the class proceeding.
So we need to provide all these parameters and these abilities, possibilities. Again, equity in its very nature is incredibly flexible and accommodating. So you need to imagine or understand that a lot of the questions that we or subclass members do have, or even public generally, we need to build those questions into the court process and then provide the court orders that satisfy those questions. So you can see that there's a bit of a journey here where, yeah, we're pretty intuitive. We're pretty good at, forecasting a little bit or projecting ourselves a little bit in the future and thinking of, okay, what are the requirements? What's going to be, what could possibly, and all these variables. So trying to dial all these what ifs into a presentable format so that the judge and the court can make a sound decision. Again, I compare it to sculpting, chiseling out little bits at a time, putting a piece back and reworking it. This is a process that just evolves. It never stops. So again, back to the 7, 14, 21 years old, there's a whole bunch of elements there that we need to consider, and we're building them in.
Okay, so one question that we had was a lot of young people, they're in school, they have after-school curricular activities, and they were questioning as far as how many hours that they could dedicate to the Trusted Life Training Program. Now, you have to remember is that we are wanting to introduce equity into classrooms around the world. So they're learning about this kind of stuff. So you're not learning about it at a later age where it's coming as a shock to you. So this is what's going to be great is that even if you are someone who's going to school, you're probably going to be learning about equity between 7 to 10 hours a week, at least an hour a day, because that's what equity would demand.
This is considered this a secondary discipline. Whether it was martial arts or studying in school, we need to carve out a little bit of time so that we can devote or dedicate that to our greater wisdom moving forward. And the more, the better. That's what it comes down to.
And additionally, as well, any subclass members, we're going to have some quiz questions coming up in this class. So please make sure you jot down question number 1, what you answered, and whether or not you got it right or wrong, because you're going to be asked to submit that for your record of involvement. Okay, so let's get into this. Just one moment. Okay, where's my thing? Here we go. Okay, so this should come up. All righty, here we go. This is today's outline. Now, I know that we put up that we were going to be reviewing the poll quiz questions from the last couple weeks. However, we really didn't have anyone come forward with questions about any of them. There was one question that we're going to be addressing that got quite a few of you in as far as what are the parties involved who are creating a trust? And there were options between grantee, grantor, beneficiary, trustee, the settler. So we're going to be expanding on that a little bit more moving forward. So stay tuned for those. But this class, we really want to dedicate to how your life affairs operate in equity. So we're talking legal versus equity, dead versus living. This is like the real man and woman, the real child, Satan versus Father, black and white. It's the complete opposite, like we said, of anything that we have come to know to be. So a lot of this is disturbing. A lot of this ruffles you. A lot of this will make you question what gives us the right. However, this is going to give you Divergence version of this, equities version of this, and what we're going to be bringing forward to the courts with this class proceeding as far as how all of these things are going to roll out. It's all part of our workable plan that we have to be able to submit to the court for the class proceeding. Number 2, we're going to talk about a legal business versus an equitable charity. Very different. In business, we're used to paying our employees and our company expenses certain way, but it works differently in equity. We're going to speak to that. We had a couple of those questions on our Telegram channel already. We're going to talk about what it means when a business is not for profit in equity, because again, it's different than in legal. And in equity, can you charge for your time, product, or service to the public? This is going to be a real mind bender for you, which is outline number 4. What must happen to the assets of the all caps name for a man or woman to enter into equity? So you're going to notice that what must happen to your assets, such as your RSPs, your mutual funds, your TFSAs, your bank account, crypto, for a man or woman to enter into equity. So this has to be established before you get there. This is the reason Divergence is doing these kinds of classes. So you're not joining the class proceeding only to find out how equity works and you not perhaps be in agreement with it. So this is full disclosure. And number 5, in equity, what will happen to the debts and ongoing bills of the person? So these are things like your mortgage, your cell phone bill, utility bills, these kinds of things. And then what happens if those debts or ongoing bills are attached to another person who isn't a subclass member?
Like your wife or your husband or, possibilities.
So this will affect them. So you're going to need to know this information if you're wanting to join our proceeding and move forward with us. And number 6, the equitable duty of a divergent subclass member. So this is something that it has is an addition to our AAA. We've made a few little amendments, which you're going to see is really going to enable people to be able to access their life estate even before they've fully gained access to 100% of it, to be able to provide funding for organizations, programs, charities of those in need. Organizations that you believe in, that are near and dear to your heart, that help Mother Earth, help her animals, that help aid children, mothers, and like we said, people in need around the world. So very exciting. Just one moment here. Don't know where that went. Okay, so, pardon me. Let's start with our first question, loved ones. The best way for divergence to be able to lay out all of this track that we need to is to ask it to you in a question form. Not only is this going to test your knowledge of equity and how it works legally right now, it's going to grow your knowledge very quickly. So here's question number 1. Is this how equity actually works, or is this divergence version of equity? So what we're about to lay out, do you guys think that this is actually how equity works, or is this divergence version? So A, it's how it works, it's divergence version, or C, all of the above. Please put your answers into the chat, please. Okay, we've got C's across the board. That's right, loved ones. It's a little bit of both. The reason for this is because we recognize that there are individuals that are in equity that are abusing it, that are not using it the way that Father or even equity intended it to be. So there needs to be a purge. People who are abusing this or misusing equity need to be removed. However, divergence is going to have the ability to be able to restore equity back to what it used to be, its original state or jurisdiction.
This is, again, a larger scope that most people aren't really even capable of trying to, wrap their minds around. However, when Jesus himself walked into the temple that day, he was flipping tables. So he was upset. And again, the flipping the tables, whether it's metaphor or literal, this is to ensue or to show us that there needs to be something changed. And the change is the economy, how money works, how obligations work, and all this, that, and the other. So restoring back to what it used to be, and then it got, taken over, hijacked over the last 2,500 years, but we're trying to get back to where this is supposed to be.
So let's go to question number 2. Now this one's loaded. Again, another reason why we like to use questions is because we can put a lot of statements and truth into them. So what is the court, or why is the court likely to agree with divergence version of how equity really works? A, it's in the public interest because it will bring down the national debt. B, it's aligned with equity's maxims and jurisprudence. C, it's aligned with Scripture. D, it will remove any currently abusing or misusing equity and prevent it from happening in the future. E, it will ensure moving forward that equity is only used for the greater good of all involved. F, divergence can offer a workable method to return a person to life and advance their knowledge of equity and the perfection process for themselves. G, divergence workable plan is not vexatious, frivolous, or abusive to any party involved. H, divergence workable plan is not an improper or unnecessary application or method that will delay or increase costs for an improper use. I, divergence workable plan is not unjust, and it will not deprive a successful party of any reward entitlements or costs. Or J, all of the above. So what do you guys think? Why is the court likely to agree with divergence on what we're going to be laying out here? There's a lot of answers. We know that. Oh, my chat's not coming up here. There we go. All right. It was kind of an easy one, but you bet your loved ones, it is J, all of the above. However, answer number A, it's in the public interest because it will bring down the national debt, is the primary reason.
And again, anything done in the public interest, whether it's legislative bodies or the judicial bodies, they must put these things through, because again, when it's in their interest, how could they not? And again, this is all part of the background, what allows this process to actually happen. And because it's aligned with all these other aspects, again, the court is only going to be here to, we advise this, or we suggest this, or we will do this order. This is why you need those courts' involvement to help shape this properly. Remember, in a class a while back, we were talking about how if you don't involve the court in trying to develop and create your trust and all these other methods, don't come to the court later for advice or, help. Their answer is basically, well, you should have came to us in the beginning. Now you're just wasting our time. So we had to be a little bit mindful of all of this. So again, moving forward, they need to approve a workable plan that's not vexatious, frivolous, or abusive to any party involved. Now, this is important because we're going to talk about bad faith in a minute here and where that comes from.
Now, this is one thing we did want to touch on as well, which was answer number F, that as far as this workable method that we're presenting to the court, that it helps return the public back to life. And it helps them advance their knowledge of equity and the perfection process through the training program that we are offering. So this is why the individuals who are not wanting to join the class proceeding, should they start expressing similar claims as divergence in any other court or trying to bring that forward to a registrar, that's going to be indicated that our case is already present and offering that. This is what we found, is that most loved ones aren't assisting others. They're not offering a way for other people to be able to come into equity, to be able to perfect their interest, and to do it in the spirit of equity, where it's done justly and correctly. So this is why the courts will avoid a multiplicity of suits, and loved ones who are wanting to go on their own and perfect their interests without divergence, please understand that because we have had our case in since 2022, once we send forward our notice of intent to proceed, this is going to change everything. This will capture equity worldwide. And that's why we're offering the class proceeding, because we can offer something to the judge, to the world, as far as a workable plan that benefits those that are involved. Anything in blue here is taken from the Class Proceedings Act, loved ones. So this was why we included it in these answers, and we're just going to give you a refresher on that under Part 5, Costs, Fees, and Disbursements. A court referred to in subsection 1 may only distribute entitlement awards, such as the Dicera or the Crown Credit, in respect of an application for certification or in respect of any part of a class proceeding, provided that, as you can see, Section A, that the court can verify that there's been no vexatious, frivolous, or abusive conduct on behalf of any party. That's on behalf of divergence, and that's also on behalf of you, loved ones. B, that there's no improper or unnecessary applications or steps that we're putting forward that are going to cause delays or costs or an improper purpose or for an improper purpose. And that there is nothing that would be unjust or deprive any successful party of receiving unrestricted access to their life estate or extra Dicera or Crown Credit. That's all been built into our workable plan.
And again, the workable plan is designed specifically, and I mean very tailored, to motivate you. It's to give you some relief, but not all of it. And then it's to compel you to want more and want more. And as you develop like a flower, eventually you are going to be so enamored by what it is that you actually know and have come to appreciate. It's going to feel like it happened instantly. You're not even going to really remember how and why this came to be. It's a beautiful blur.
We wanted to continue on this because if you actually go up and look the legal definition of what vexatious and frivolous is, because you got to remember the OPCA, organized pseudo-legal commercial agency. When you bring anything forward about a birth certificate into court, you're going to get slapped with OPCA that you are a vexatious litigant. Well, let's flip that on its head in as far as what we're bringing forward, as far as trying to bring equity and life estates to life. This was actually taken from the Government of Canada website as far as what a complaint is when it's frivolous, vexatious, or made in bad faith. Because remember, a complaint is just like what's that word?
A claim.
A claim. Thank you. A claimant that's coming forward. So notice frivolous. It means lacking a legal basis or legal merit. Again, remember, if you have no legal basis or legal merit, you certainly won't have it in
And there
equity.
are very, very sticklers when it comes to this. Your cause of action, you need to entertain. There's about 5 elements that add up to a cause of action. It's not simply one little sentence where you state a simple claim. No. You have to, state the claim, provide the evidence, provide the order, provide a whole bunch of things that manifest a cause of action. And I've seen, I don't know how many times where the courts bounce back paperwork because it doesn't satisfy. they deem it to be not a worthy cause of action. And we're going to talk about bad faith here.
Frivolous continued says a matter that has little prospect of success. It's not serious. It's not reasonably purposeful. Vexatious means without reasonable or probable cause or excuse. Harassing, annoying, instituted maliciously or on the basis of improper motives intended to harass or annoy.
Okay, so remember back in the day there when I was speaking about what's the definition of a plaintiff? I haven't met very many people that even simply know that. Remember, it's a party attempting to recover a security interest attached to a certificated security. So if you go outside of that scope, if you start talking about any other aspect, you're actually not even making the prerequisite requirements, that you're not even fulfilling the obligations and duties of what a plaintiff or a complainant or a claimant is actually supposed to be doing.
And I'll get you to talk about bad faith.
Okay, bad faith. Remember when we're talking about when we're in adverse possession of a security interest that truly belongs to the crown and or his or her majesty, when you are in adverse possession, you know what that's called? Here's a synonym for it. It's called bad faith. So unless you're showing up to court trying to dispose of your problem, you're actually showing up in bad faith, and you're actually wasting the court's time because you're not truly dealing with the actual subject matter problem at hand. That literally says, unless you're showing up to deal with the security interest problem, you're coming in bad faith. And again, they allow us to sort of make a spectacle and do all these things, and then the judges will eventually balance you out. Yes, so again, they have to maintain this persona or this illusion that this acting and this whole mechanism is there for our best and highest interest. But again, if you're coming in bad faith, they do not care.
Question number 3, how will it work for those in equity that still want to be employed, have their own business, or want to start a new business? A, you're not allowed to work, have your own business, or start a new business once you're in equity. B, you can charge for your time or services provided the amount is reasonable and in the spirit of equity. C, you can still be employed, keep your business, or start a new business provided your time, services, and business are not for profit. Or D, nothing changes, business as usual. What do you guys think? Okay, we've got lots of C's coming in. We can tell the ones who did this on our Telegram channel. Very good. We actually took a little snapshot of what the ratings were as far as who thought what on all of these answers. You can see quite a few people thought that you're allowed to charge for your time or your services provided it's reasonable and in the spirit of equity. Some of you even thought that nothing changes. However, in equity, you can be employed. So if you're still working at a florist, for instance, and you perfect your interests and you want to still work there, that's fine. However, you can no longer charge a wage. If you have a flower business, you can no longer charge a wage for your time or for any flowers that you would be giving away. Is there anything you
This is where our mindsets need to really, really change. Imagine, when you show up in spirit, you're gifting, you're donating, you're charitable in nature, you're giving and all things of this nature. As soon as you want to introduce profit into this situation, now you're falling back into the legal world. Here's my simple advice on this one. Once our hands are clean and we're in the land of safety, or we're back in the garden, we should be serving Father and Creator. And if you want to charge a fee to serve Father, you see how that's not going to work. We need to stay clean once we get clean, not jump back in there. Again, when you have abundance, you're not going to need to do some of these other employable aspects that we're normally accustomed to living with.
So let's keep building on that. Question number 4, how will business expenses and employee wages operate in equity? A, they are invoiced to your individual representative for extinguishment from your life estate. B, the receipts are submitted to your personal representative for extinguishment from your life estate. C, the receipts are submitted to your personal representative for reimbursement from your life estate to your company's bank account. Or D, nothing changes because the company needs business expenses and wages for tax write-offs. So this is really the difference between, does anything change? Do you submit receipts or do you submit invoices? Okay, again, This was on our Telegram channel, and many of you remembered the correct answer. That's right, it is invoiced. This is a big deal because right now in legal, you have to pay for everything for your company, and then you usually submit those receipts to the government for a tax deduction, and whatever's left over is what you pay tax on. That's not how it works in equity. You send the invoice of whatever the expenses are that you need for your business, whatever the wages are to be able to employ those that work underneath you, and then that is extinguished. There are no receipts required, which is wonderful. And we also have to take note that if you are moving into equity, something always has to change. When legal is the complete opposite of equity, you have to know that whatever you know it to be, it's going to be the complete opposite. That's why we actually teach equity in polarity. How do you know it to be in legal? And imagine the complete opposite, and that's almost always how it works in equity.
So again, when we are not participating or volunteering with the entire tax scheme as we know it, when we're not partaking in public interests, we remove ourselves from the liability, or you literally are exempt. Again, this is a lot of the fundamental principles of a trust and why people would create a trust to protect family assets or business assets generally. A lot of the problem there, though, is again, these individuals coming to create a trust on the legal side, they're all still operating in bad faith and bad in an adverse possession. So are they really truly creating trust and equity? No, they're not. Remember, the legal is an illusion. It's a mirror. It's a smokescreen. It's meant to look like equity, but it's not in its roots.
Okay, so these are going to be some newer questions coming up here soon. We're going to finish up with the ones that we had on Telegram, though. How does a not-for-profit business operate in equity? So A, the business cannot charge the public for any time, service, or product provided by you or your employees. B, the business can only charge the public what it cost to make the product or provide the service after expenses and employee wages. C, a man or woman in equity can charge a public wage but must volunteer their time for a business or employer. Is it D, which is A and C, or E, B and C? What do you think? Holy smokes, you guys are like record fast today. D's. That's right, loved ones. Here it is on Telegram. 59% of you guys got it correct. That's wonderful. We had some of you thinking that the business can't charge for any of the time or for employees. Some thought that you could charge, but as you can see, the correct answer is A and C, because we do not want to use equity to place a charge on the public or our brothers and sisters moving forward.
So just as a quick summary here, again, your initial reaction to this is, well, then where do we get the money to pay our wages? And if we're not charging for our products and services, how does this all work? Well, remember, when you're bringing down the national debt, you're literally extinguishing all your costs, all your operating overhead. It's all bounced against that national debt. Or imagine there's a blank check waiting for you. You just got to show up and write your name, the trust name, and the amount that you need this month. We need to completely revamp the way we think the system operates, because the system that's coming isn't going to be very little like what we're leaving behind. It has to be.
So if you have your own florist business, you can write down what flowers that you're going to need for the week. If you're going to need any expenses for gas, for delivering things, for ribbons, for wrap, all that kind of stuff, you submit that to your personal representative. Your personal representative goes and arranges all of that for you and has it delivered. So you're just basically figuring out what you want and you're adding it to your cart. Add to cart, add to cart.
And again, remember, loved ones, the principle of a personal representative, another word for that is a commissioner. A commissioner follows you around with a clipboard and a pen and literally takes all your orders, instructions, and directions, just like the King and Queen of England do. When they need anything done, you don't see her or him reaching into their back pocket and pulling out cash. They snap their fingers and the commissioners run and go do it. This is, again, having priority over the government actually implies that you are directing the puppet show. You don't need to touch the money.
Stay in the Ferrari. Okay, so now we're going to move into some questions you haven't seen. So this is where we're really going to be testing your knowledge, loved ones. So let's see what you got in the chat. Will employees who are not subclass members have to pay taxes on their income if their wages are being extinguished in equity. Okay, so if you got this florist business and you're sending the invoices for your employees' incomes to be extinguished and they're getting paid, do they have to pay taxes on that? Yes or no? Okay, so we've got no's, no's, no's. Wow, very good. This question came up while we were creating this, and well done, loved ones. There is no tax. The income will be tax exempt. So what's that mean? All of your employees just got a raise. That's what's wonderful. The wages, however, that are going to be extinguished in equity will not be paid in credit. It will not be paid in real gold or silver or anything along these funds. It would be paid to the person in kind. So it'll be directly deposited into their bank account. They can request cash or a check. And we're leaving this a little bit open in the event that the court has another means in which that they would like to be able to give those funds to the employees. However, right now, pretty much nothing changes except that they don't have to pay any big chunk of tax on that.
And again, all these aspects and elements, this all falls under the umbrella of administering the trust generally, which is what the trustees are running around in the background doing. They're there to serve you, not the public anymore. Again, taking priority and having that power means that you aren't so much as employed as you may have been. If you love doing your job, go do it, but volunteer. Don't accept wages of sin. You actually can't negotiate that anymore. And again, remember, if you have access to what we're talking about here in the background, why do you need to go make an extra $29 an hour and then have all the tax system appropriate and disappropriate and monkey with all that funding? We're literally suggesting that equity is going to remove all of that process. We're not going to need to do any of that when we're directly dealing through the minister who's going to do something magical for us here. We're going to show you in a minute and open up a door so that you have the access to what it is that we're talking about.
So we have a question on the chat as far as is cash not debt notes? Yes.
Yeah, it is.
But these are individuals or employees who want to remain persons. So the persons get paid in kind. They get paid the money of persons or the currency of persons.
Until they, again, put up their hand and say, hey, I wish to change my position in life. And changing the position is what we're talking about here. And once that's, again, approved, ordered, agreed by the court system, now you can't cross that line again. Now you got to stay squeaky clean, if you will.
Okay, so is that not adding back to the national debt again?
It is, but eventually this is going to be like a progressive loop, whereas the equity grows and the public debt diminishes, eventually that whole system will be replaced. It'll be placated. It'll literally become redundant. It's very much in its, I would say, mid-ground. Again, I was looking at documents from 2015 and 13 about having a security interest over cryptocurrencies. Okay, so people are so focused on the cryptos, but look, they missed that part. The securities that are backing the cryptocurrency. And we're not talking about just public debt notes here. We're talking about something of an intrinsic value, not just cash debt for crypto. No, there's something else brewing in the background.
And I would put a little bit of an argument in there as well that we're not adding to the national debt because it's already been extinguished in equity. So it's almost a little bit of a wash. The invoice is submitted, the life estate extinguishes it, so then we have to pay it in kind to that person because that's how they're insisting that they operate in legal. So we have to be respectful of that. Okay, so next question, number 7. This is a beginner question. A business in equity must become trust property to operate outside the law and not be subject to taxes. Is that true or is that false? Oh my goodness, look at you guys learning. You're punching in your answers so quickly. Well done. And you're correct. This was on Telegram. 80% of you got this correct. A business has to be trust property if you don't want it subject to the rules of law.
And this is where, again, any property that's identifiable or has a characteristic, whether it's some type of legal description or some identifying number or some type of way that it can be listed by a statement, it would then become the trust asset or an equitable asset or a trust property. And once it's at that position, or once it's in that spot, now it's not subject to the same taxation laws. Again, you're going to find out as we go through this how everything's about to change. So we need to close the door on what we used to think. And again, you know, Dean and mine's dad was very much about, you gotta pay your share of taxes, and you gotta, you know, support that whole tax incentive. But again, remember, we volunteered for that. And rather than volunteering for that, when we're creating a trust properly in equity, that's a different realm altogether.
Question number 8, in equity, for a class member to be the beneficial owner and enjoyer of any property, such as a home or vehicle, the asset must become trust property. Is that true or is that false, loved ones? To be the beneficiary, does property have to be in trust? True, 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 trues. That's right, loved ones. And majority of you got that right as well.
So when you are expressing I feel moved by spirit today to go and enjoy that car, although it's sitting on a car dealership lot. Again, this is where your personal representative literally can go in and do the deal and come out with the keys in probably less than 5 minutes, because there's so much going on in the background that once these dots connect and that switch gets flipped, so that you again now are holding that power. Again, superheroes don't go and pay for things, or Jedis, right? They just show up and they use things, and when they're done, they just set it aside, or until further notice. I'm going to use this car until further notice. Why? Because no one else has expressed a proper interest in it. Look, it's sitting there. Is there a sale pending? No, great, then I need it. That's the power we're talking about. Again, did you see me reach for money? No, the conversion, the exchanges, the extinguishments are happening in the background. Trust me, those transactions are happening, but they're not of my, I don't care how they go. I don't care how they're applied and how they're implemented.
Okay, this is an experienced question. Anything moving forward now is brand new. I'm sorry, I know we threw a couple of little repeats in there from the Telegram channel. However, for this one, in equity, what happens to the person's investments, such as an RRSP, a TFSA, a mutual fund, a bank account, or crypto? So if you want to move into equity, what's going to happen to all of those legal assets that you have? A, the assets are converted into credit and added to the subclass member's crown credit. B, the assets are converted into cash, and a sheriff will deliver it in a suitcase to the subclass member's place of dwelling. C, the assets are consolidated, and a certified check will be issued to the subclass member. D, these assets are all founded on fraud and wrongdoing and are not permitted in equity. E, crypto is a different form of currency and permitted in equity. F, a subclass member may keep the person's investments provided they don't ever cash them out. Or G, D, and E. What do you guys think? Okay. We've got a bunch of A's coming in. A. So lots are thinking it's converted into credit and added to your crown credit. Okay, it looks like a sweep on A. The correct answer is D, loved ones. All of these assets, RRSPs, TFSAs, mutual funds, bank accounts, and crypto are all founded on fraud and wrongdoing and will not be permitted in equity.
We're trying to bring in the old into the new. And what we're suggesting is, once you have the fruit and the milk and honey from the new, you don't need any of the old, literally any of it. Now, I know in past episodes we've talked about, okay, when a bank has certain instruments floating around out there in the markets, and you know, when they can monetize these things 23 times, that there's some value to that, is there? Well, you know what, when you have abundance, do you care what any of those instruments are worth? Are you interested in even chasing them? Are you interested in your $1,400 a month from RRSPs now, when you have all the abundance that we're suggesting over here? No, what we're suggesting is, because those all those transactions are entered into with bad faith, no intent, or not the proper intent anyway, that all constitutes fraud and wrongdoing and dirty hands. And we're suggesting that equity is not going to want to take part in any of that. Why are we going to still try to hang on to, cling to, cleave to, bring with us any of these dirty, filthy, adverse situations? No, equity is going to say, listen, you already have the best of the best. Leave all that behind. Again, Christ and his brothers were saying, when you're running and you turn around, you might get turned to stone. So leave all that old stuff behind you. You're not going to need it.
And this is why these kinds of assets have to be forfeited and abandoned before entering equity. You have to remember, loved ones, a legal asset, your RSPs, your crypto, it's debt in equity. Whether it's debt or whether it's an asset in legal, it's still extinguished out of your life estate in equity. So even if you could bring, for instance, your RSPs with you, they would be extinguished because it's debt that you're bringing over. This is why
you have literally more funding than the government spends for all the RRSP program for everyone in Canada. So again, we need to start talking about apples and oranges here and not get confused between the two.
Here's another reason. When we talk about it's got to coincide with scripture, this is taken from Matthew 6, verse 24. No man can serve two masters, for he will either hate one and love the other, or else he will hold to one. That means that you are in possession of one. And if you are, then you will despise Father. You can't serve God and mammon. In another translation, it says that you can only be loyal to one and despise the other. And this is why you got to figure out who your master is, loved ones. You can't be showing up in Father's garden, in Father's world in equity, and have a backpack of Satan's currency. It doesn't work like that. So this is why verse 19 says, lay up treasures in heaven. Do not lay up treasures on earth, where moth and rust destroy and where thieves break in and steal, but lay up for yourselves treasures in heaven, where neither moth nor rust destroy and where thieves do not break in and steal.
So you can get this feeling or this sense of entitlement when Father is blessing you with, the bounty of the earth. You are suddenly feeling, okay, yeah, you don't need the $100 bills in your pocket. The meek shall inherit, but it doesn't say anything about they will have to, still, be playing with Caesar's coins, laying up treasures in heaven. You can see how this has a credit feel to it. Everything else will rust and break down and, turn into dirt, but not credit. Credit is an idea. It's an intangible, it's an incorporeal hereditament or an incorporeal right. This is of the ether. Again, the blessings are coming from that, not from a bank handing you a briefcase full of $100 bills.
And that's why verse 21 says, for where your treasure is, there your heart will be also. So if you are an individual who loves money, loves making profit, loves things of a earthly nature, then equity is going to be a really hard switch for you. Proverbs 10 verse 2 in the King James Version says, treasures are wickedness. Treasures of wickedness profit nothing, but righteousness delivereth from death. Now look at these different versions here. Riches gotten by doing wrong have no value. Look at this one. Riches that are gained by sinning aren't worth anything, but doing what is right saves you from death. The New English Version says, ill-gotten treasures have no lasting value. Righteousness delivers from death. So this is why it was made for us to believe that the more successful we were and the more money that we made, the more we stood out, the more we should be proud of ourselves. But you can see when it's in equity, it's actually a hindrance. It's something that doesn't have any value.
And again, remember, there's that kind of a secondary maxim that reads, one shall not profit from his wrongdoing, as the title of this document. So again, when you're trying to profit from being in adverse possession of that interest, everything you touch and transact with is going to be filthy. And you will not be delivered from death if these are still things that you are lusting for. If you're laying in bed at night wondering and you're consumed with where am I going to get that cash for tomorrow? See? Okay, so look at this guy. He's trying to convince this little girl here, give, dispose, and you shall receive. My child, I have bigger plans for you. Trust me. So again, so you see here, the little girl, but again, this little girl, I'm going to suggest is like most adults, if not virtually 99.9999% of them, if they don't see it, they don't believe it. So just because someone here with a loving smile is extending his hand, but you can't see what's in or behind his back, most people are going to be hesitant. They're going to be on the fence. They're not going to want to take that leap of faith. They want to cleave, hold on to, or be attached to the little teddy bear. When, again, how are you going to walk into the garden and accept Father's blessings when you're holding on to the little teddy bear from Satan's land? It's not going to work.
So there's the saying, ask and you shall receive. Well, give, dispose, and then you shall receive.
Again, so this is a bit of a, I don't want to say it's an untruth or a fallacy, but you need to see how we needed to set something in motion just before you ask. You got to get rid of something. And again, this is where the sinner is going to want to have clean hands. If you enter into any contract in bad faith or dirty hands, that contract is technically void or of no force and effect at all. But when you volunteer every year and you continue to volunteer in every transaction, although the maxim is teaching you something different, we still behave in the opposite fashion. So again, being caught in the two worlds, commingling, serving two masters, we need to start making some decisions here.
We have another experience question. Number 10, in equity, what happens to persons' debts, specifically mortgages, lines of credit, and vehicle loans, including any ongoing bills, such as cell phones and utility bills, if they're attached to someone who is not a subclass member? So this would be a spouse or a parent. A, 50% of the mortgage debts and ongoing bills will be extinguished by Dïevergent Foundation Trust, and the other person is responsible for the rest. B, 100% of the mortgage and debts are extinguished by Dïevergent Foundation Trust, and ongoing bills are extinguished monthly. C, the subclass member and the person who is not a subclass member will be removed from the legal titles, including ongoing bills, and placed in trust. D, the home or vehicle will become trust property until the subclass member can manage their own equitable life affairs and they are taken for granted back. E, the subclass member chooses how they would like the trustees to proceed with the extinguishment of any debts and ongoing bills from their life estate, including anyone attached who is not a subclass member. F, A, C, and D, or G, B, C, and D. We're going to give you a minute to read that over. Okay, we've got a lot of G's, which is B, C, and D. Let's see how you did. That's it, loved one. You're starting to get the hang of this. Just because there's an individual that's on a bill or a debt with you, they are not responsible for the other 50%. The entire thing is going to be extinguished. Any ongoing bills are going to be extinguished monthly from Dïevergent Foundation Trust. And anyone that's on legal title is going to be removed and it's going to be replaced with the trust.
So again, remember, this is where the legal title goes back into the trustees. I will show you eventually one day here where, for example, in the court process that we're developing, in the orders, it literally speaks to how property and the legal title in the trustee, ... the beneficial interest or the indefeasible title is not to go with the trustees. There you go. So again, you don't want to be concerned with the legally owning it. If you are, you're missing the point.
So we want to draw your attention, the loved ones, to number D, that your home or vehicle will become trust property until the subclass member can manage their own life affairs and they're taken for granted back. So this is where once you have unrestricted access to your equitable estate, loved ones, we're going to be granting that all back to you.
And again, that's not us. That's the court granting it back. That's you making application on your own saying, hey, Your Honor, I'm ready for the whole deal. What do you think? And the judge is going to look at your stuff and say, yeah, let's give it a whirl. Let's see what happens here.
Now, to avoid having too many questions or answers within the question, we wanted to add a few more things onto this question as far as what happens to your debts if another person is on there. A subclass member who has a mortgage. So if you're in a home right now where you're paying mortgages, the home will be put in trust until such time as it's taken for granted back and allocated as your primary trust residence. So every subclass member can have a primary trust residence. So if you like the home that you are in, that will automatically be your primary unless you decide to change it. Any ongoing bills will be diverted to the subclass member's personal representative for Divergence Foundation Trust to manage an ongoing extinguish for you. So these are cell phone bills, utility bills, whatever your life requires to be able to exist or that you want to have in your life, you just submit those to the foundation and we take that out of your Crown Credit.
Yeah, the trustees literally, again, they take over here. Again, when you, let's say you settle down into a property that you're pretty happy with and you see yourself here for the next 5 years, the utility companies will not be sending the hydro bill, the power bill to that property. They will actually direct payment to the trustees, and it's probably going to be at their address, or the courthouse is another option. But again, it's not going to be coming to you. You're not going to have to worry about opening the mail and, oh, there's a bill. Like, we don't care about that. That's their job.
And then any real property, such as a vehicle, a boat, a trailer, would also be put in trust until that was taken back for granted. Now, as far as recreational homes, cabins, secondary residences, these are, of course, permitted in equity. However, they have to be supported by your current DSERA or Crown Credit eligibility. Now, what does that mean? Well, that's going to take us nicely into question number 11. In equity, for a subclass member to have the beneficial use and enjoyment of Crown property, the subclass member must notify their personal representative of any property they wish to own, and subject to the subclass member's available DSERA and Crown Credit, the personal representative will acquire the property on your behalf and credit any applicable debts for extinguishment to your life estate. Is that true or is that false? Okay, true, 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 true. Oh, loved ones, this is what we would call a tricky question. And here's why it's false. Anytime you see the word own in there, dispose of it. Do not touch it. Do not go anywhere near it. This is how this sentence should have read in order to be in alignment with equity. For a subclass member to have the beneficial use and enjoyment of Crown property, the subclass member must notify their personal representative of any property they wish to use, not own. And subject to the subclass member's available DSERA and Crown Credit, the personal representative will acquire the property in trust. They will not acquire it on your behalf or put it into your name. Okay, it's a little tricky on there, but this is why we graded it as a beginner question, because we're trying to really help you see the importance of not owning things, using. This is new language.
And here's again, in summary, when we are crediting or depositing, specially or otherwise, our security into the court, we actually make it into the name. We literally deliver and deposit into the name of the registrar, district registrar, or of the court. So right there, we're already saying, no, it's not attached to me the same way. It's in the registrar's name. And then there's a third step here where the registrar then does something with it to another somebody else. So you can see where you need to be able to when you pass legal title, the legal title is passing right to the registrar. In technical theory, he or she legally owns it for the moment, but then they're going to want to transfer that out of their possession as well. And we'll explain that why.
Okay, let's keep going here. Here's another advanced question. This is rated red for hard. In equity, if a subclass member wants to acquire the beneficial use and enjoyment of a new home, what will happen to their old home? A, the total value of the old home will be credited to the subclass member's Crown Credit and may be applied towards their new home. B, Any home or homes used by a subclass member will remain in trust until a judge declares the subclass member has unrestricted access to handle their own life affairs and they are taken for granted back. C, to avoid equitable waste, Dïevergent Foundation Trust may grant the beneficial use and enjoyment of the old home to another subclass member or person in need. D, if a couple are both subclass members, they may keep using the old home for their beneficial use and enjoyment by allocating it as one of their primary trust residences. E, A, B, and D, G, C, and D, or H, all of the above. What do you think? What happens when with the old when you want the new? Okay, we've got E's and G's and H's. E's, G's, and H's. Lots of those ones coming up. Okay, and we got another G in there. Very good to those ones that pick G. What happens to your old home? Well, to avoid equitable waste, the foundation, the trustees could give the use of that to another subclass member or person in need in the public if they wanted to donate that. Or if you're with somebody, if you're a couple and you want to go into a new home, the old home can be designated as a primary trust residence. So please remember that the trustees have a lot of power in as far as how to deal with the assets, how to handle them, who's going to use them. It's our job to stay the beneficiary. We don't get our hands dirty. We just add things to the cart as far as what we want to be able to use. Refrain from owning things. There's no more mine. And that's where the great power comes in, and freedom is when you use things and you don't own them. Okay. All right, let's go on to question number 13. We're doing good here. Once a judge in equity declares a subclass member has acquired unrestricted access to manage their own life affairs, the subclass member may request any initiative, business, or charity they started be taken for granted back to their life estate in whole, with no further oversight or protection from Dïevergent Foundation Trust. So if you bring over a business into equity, you start a new business or charity in equity, once you perfect your interests, will the foundation give or transfer those back to you in whole? True or false? My goodness, you guys are doing so great on answering your questions today. Well done. We got sweeping truths. And yes, we're not here to hoard property. That's not the point of this. It's in trust, so it's managed, it's cared for you until you can manage and care for it yourself.
And let's just refer back to that word equitable waste. You know, every time you go for a drive or a walk, or you're on the train or bus or whatever it is that you like to do, just start painting take mental note of how many vacant properties there are around and how much, vacancy there is. We have this problem, and then we have a homeless problem right beside it. So, why someone hasn't taken those people and refurbished these buildings and put them into these buildings, is a little bit beyond me. But again, this is where the public isn't quite as interested in their own citizens as we were led to believe.
Okay, so moving on here, question number 14. The subclass representative and or personal representative will approve a subclass member's request for extra funding from their life estate, provided that the initiative or charity, A, is charitable in nature, B, embodies the spirit of equity, C, benefits the majority of parties involved, D, will not cost or bring any charge to the public, E, has a workable plan that will advance the initiative or charity, F, A, B, C, and D, or G, all of the above. So you just have to figure out whether or not the extra funding from your life estate will require a workable plan. What do you guys think? Woo! I think you guys all answered at once. G, 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 G. And that is correct. We need to be able to have loved ones that are coming forward with plans, with the ability to know if it's in line with equity, if it will benefit the majority of parties involved in equity. It's not for the betterment of all of the world, because a lot of this will not affect some individuals. It's about the ones involved. Will it help those ones? Will it aid them? Will it not cost them anything? Will it not bring charge to them? These are all things that are important for it to be approved. And we're not going to hold that back. That's what's great about it. Question number 15, this is the last question. Subclass members have an equitable duty to always find ways to be charitable and to seek out people, organizations, programs, and charities that can help A, people with special needs, disabilities, or are disadvantaged. B, people that can provide water, food, shelter to those in need. C, that can provide better care for the elderly and those in old age homes. D, individuals that can improve the overall state and well-being of orphanages, youth homes, women's shelters, low-income housing, even correctional institutions. E, people who can help us learn how to recycle, even create self-sustained ecosystems to grow our own food. F, that can rescue and care for animals being abused, endangered, or in need. G, that can provide schools with nutritional food and drink, school supplies, before and after school care, recreational activities, sports, even clothes if necessary. Or H, all of the above. You guys should know this one. We were just laying a lot of track as far as the different individuals and organizations that Dîevergence is looking for. And you got it, loved ones. It's all of the above. And this is why we really want to imprint our loved ones that are joining the class proceeding that it is your equitable duty to help out your fellow man and those in need. Every day, we need to be looking at ways that we helped out equity. And this is why in our AAA form, entrance requirement number 5, every subclass member must agree to this, which is, I shall uphold the maxims in my daily life, specifically in exercise of the spirit of equity. Okay, well, that's really easy to say. What does that mean? That means this is something you do every day, which means equity is something you do daily. You must serve equity and your fellow man every day and be able to answer to that. And to be able to answer, how did you appropriate the spirit of equity when you have access to abundance? So you actually have an obligation to the higher powers, to equity, to be able to give that forward when you have the means in which to do so. The next one, I promise to be vigilant as equity demands of me. These are maxims, loved ones. That means equity is ordering you, demanding of you to do good works and to be charitable. And that equity will not allow you to slumber on your rights. You're not allowed to be idle here. So we're looking for subclass members that understand that. It doesn't matter if you are paralyzed from your neck down. If you have a nurse coming in that's wanting to help you and she doesn't have enough money to pay for her groceries, she needs some kind of help, you find ways to be able to appropriate funding to be able to help those that are in your world. And when you're seeking it, as equity demands, you will find it. The people will come. I further acknowledge that those who seek equity must do equity. And this means we have to rise to equity to receive it. We have to be of it and do the things that equity demands.
Remember, Christ said, you're going to do greater works and greater miracles than I did. Well, again, if you're not vigilant, if you're not actually seeking to help in any regard, you're probably missing out on the opportunity to be creating and helping propagate miracles.
And this is the reason we just did an upgrade to our AAA. Anyone who has submitted them does not have to redo this, but we were noticing that the subclass members that were joining were answering not applicable or no to question number 17, which was in respect of making application for an individual with severe disability, special needs, or disadvantage. So now what we've done is we've built on that to include programs, charities, or initiatives that you can now choose for 3 things to happen. So we recognize that many were saying no, or it wasn't applicable because they didn't have another individual's security interest to be able to attach for the NESARA or the GESARA to come off of. So we recognize that. So while we did still incorporate that option, you can also choose, which is a little bit further down, to fund this individual, initiative, charity, or program with your own individual life estate for any appropriate care, support, or extinguishment deemed fit. Or you can ask Dîevergence Foundation Trust to support this individual, initiative, charity, or program for any appropriate care, support, or extinguishment deemed fit. So if an individual, for instance, is not eligible to join our class proceeding, you could fill out this form and request Dîevergence to be able to look into this charity, this initiative, this individual with this disability so that the foundation can support them. So this is where we're going to give those individuals with the beautiful hearts out there that just perhaps aren't eligible to join the class proceeding to be able to go and work your miracles as well. And this soon we can see being a requirement to join our class proceeding, where you need to find an individual or a charity or someone who is disadvantaged to bring forward to join the class proceeding. Why wouldn't you? Show us that you can go and appropriate equity, that you could find those that are worthy and entitled of this and bring that forward with a video explaining why and how you would like that to be funded out of your estate. That is some very good karma and dharma that's put into the ether, loved ones. And this is going to get us thinking the way we need to be on entering equity. Okay, that is actually all we have for questions today. I can't believe we got through this so quickly. Oh my goodness. So let me go through our questions. Let me see if there was anything that we didn't cover. So loved ones, do you have anything that we talked to in this? Because we're noticing a lot of you aren't asking questions. So the majority of these questions are ones that we develop so that we try and plug all the holes of future subclass members wanting to join to see if, okay, what if someone says this or someone says that or someone comes in with this situation, so that again, when we bring this to the court, we can show them that we are competent and we have handled this in all areas.
And the other, the most positive element here is that the flexibility that's created with this order in the court process is that it's amendable. I fully anticipate amending our order at least once a month. Amending it for what? Well, if a subclass member wants to be removed, or adding subclass members. Remember, so every month there's going to be a new batch of people at some point being added to the order, where we constantly are moving this order around and shaping it. It evolves and it will adapt for every situation that we run into. If we do run into something, oh crap, we never thought of that. Guess what? We just amend the order and we make it work. So there's nothing stopping us moving forward. Only your own imagination, or if you're not capable of dreaming big things, okay, well, that's going to be something we're going to have to help you with.
So we're polishing this. We are trying to create more charity into our form, our AAA, and into the perfection process. This is what's going to be wonderful about children that are joining, who are getting the DSERA and the NSERA, that they can actually go and appropriate this to their children, that they are their friends that need some extra help. Maybe their friends don't have shoes or a jacket, or this is why we need people to come in and to help and to give forward. We don't need more problems brought forward. We don't need people coming saying this has to be fixed, that has to be fixed. No, we need a workable plan. Who do you know? What organization out there is currently doing that? Maybe you are an organization or a program that can help some of the situations that we're looking to heal in the world. Please step forward.
Because again, we do have a short list where this is going to be our primary focus for X amount of time. And again, it's just going to be the handful of biggest problems facing the world, whether it's, hungry, homeless, animals, things of this nature. We're going to focus on those first, and then everything else is going to be secondary, but they're just as important. Don't get me wrong, but we had to prioritize this a little bit. And in doing so, this is again what's going to allow that flexibility of the plan, the workable method, to continually evolve and move forward. And again, this isn't just something that we're just laying down the beginnings of this thing. Once we all get to a position where, pretend you're a Jedi sitting at that council, and when you put up your hand, whatever's coming out of your voice, whatever's coming out of your mouth has a profound impact on what's about to happen. So again, this is what we're looking for. A group of men and women that actually do give a shit and know how to manage their own affairs, moving forward. So again, heaven forbid, let's pretend that I disappear tomorrow. And let's say that Jody disappears tomorrow. Is there anyone in the group that would have the ability to get a hold of the trustees and keep the train moving, or get a hold of the judge and keep things moving around? Because this is something that we need to be looking at. Again, this is getting you to that ascended, elevated position. We're not interested in controlling you and keeping a thumb over you for the rest of your life. We're trying to empower you so that you're excited to do better than we're doing. And I'm doing everything I possibly can to accommodate such.
Okay, we'll take a question from Brother Brendan. Just a friendly reminder, we're not taking any individual questions about any cases. This has to be a question related to the class that we did today.
But I did see Tony's blurb there, just like Brendan, about how do we activate or get our equitable capacity going. So I will touch on that.
Yes, as long as it's related to what we're talking about.
Yep.
Okay, Brother Brendan, and then Tony, you're right after.
Yeah, I'd like you to talk through the crypto one, because I have researched and quite into the crypto, not from necessarily a wealth perspective. I see the crypto as being a really, really huge initiative that's helping the world, because it's so much in the data space and really making things a lot more efficient, really making people's lives a lot better. So there's that side of the equation. I think you were talking about the wealth side of the equation earlier. How do we support technologies and things which are really going to help the world, particularly in this domain? Thanks very much.
Yeah, I'm going to throw this out there. I'm suggesting that the cryptos that are available right now, they're not quite the version that we should be using. When you have a security-backed crypto, okay, now we're talking. Because I'm suggesting that when you take $100 cash and you go buy an Ethereum coin, you still use cash, you still use debt to acquire just another form of currency. So there's going to have a lot of debt that's still attached to that currency. Yes, the concept or the incept or the applicability of crypto, I think, is very important. It's very user friendly, and it's going to be efficient, and it's going to be, protected, and it's just for you. There's a lot of positive things about crypto, but what I'm suggesting is that at some point we're going to need a better coin that's backed against securities in our treasury account. I'm going to throw this one out there, that every life estate, every credited securities account probably could have its own crypto coin because it's backed properly. I'm going to suggest, again, remember, when we do this properly, we have enough wealth to basically start your own nation, to start your own country. You definitely have the funding to do so. Now, when the minister goes and creates a trust account for you, I'm suggesting that one of the opportunities is, I need a digital coin so that I can negotiate things in the future. So brother, I do think that the crypto stuff is a fantastic idea, but I want to focus on the security-backed cryptos. Again, you're putting the birth certificates in, that's generating a proper security-backed type crypto where it's not involved with debt. I'm going to suggest that I don't think that that's been done yet. I could be wrong. I haven't researched it a whole lot, but this is something that we would like to implement moving forward. Now, can you imagine the divergence trust or the divergence pool when you have, say, 100 members or 100 subclass members, or maybe even 1,000? And all of those people are putting their securities in. Can you imagine the value of what that crypto would be worth? I don't want to call it a divergence coin, but I'm just using that as an example. When we have our treasury account backing a crypto, I think that opens up another whole realm of possibilities.
So while we do agree, Brother Brendan, there are a lot of benefits to the crypto, we're preparing subclass members to leave it behind. It was still founded in fraud. It was still used in the person's name. It might be able to be used in equity, but again, it would be starting fresh with crypto and in things in the right place.
I think we're just going to develop the crypto idea and just kind of massage it and bring it up to another level that it's not really at yet. So I think, again, something for us to work towards. And I think that, Treasury and the account managers would be probably pretty happy with something like this.
And that's why we actually said for non-subclass members who get paid in cash and certified check and that kind of thing, that's why we kept that open, because we actually do figure the court may be open to paying persons in crypto if they wish as well. Did that answer all your questions, Brother Brendan? Or did you have more? Okay, good stuff. Okay, Tony, we'll swing over to you real quick. Tony. Oh, there you are.
I was just trying to maybe hone in on how the application process would go in terms of allocating a trust to be the representative rather than the person. Or I'm a bit confused there.
Yeah, okay, so
We've discussed it in.
sure. I'm going to suggest moving forward, whenever you were going to make an application for anything, I don't care if it's for a driver's license, if you're going to court, or for medical something, or if you're applying for a marriage license, anything of this nature, I'm going to suggest that you actually bring your trust name forward, which again is just your all caps name, your registration numbers, and then in trust. Once it's designated in trust, that's the beginning of removing it from the public. Again, it's just step one though. Now, how do you fund this trust? Or what activates what gets this trust actually moving so that it can actually operate for our purposes? Well, I see a lot of people out there talking about they know lots about trust, but I actually haven't seen too many talk about how a capitally funded trust under the supervision of the court for distribution is what gets our ball absolutely in the court that we want it to be. So what does it actually take to establish the capacity of getting your trust up and moving? The moment that you either voice it or you write it down. Again, remember, when we're coming into court right now, this is Clifford Trust and Levy Trust making application as the plaintiff. Darren's not named in the entire thing. Just the trust is. Now, the court is going to want to see, okay, does Darren know as the settlor or beneficiary, or even the trustee trying to create a trust, does he know enough to get this thing properly moving? And again, this is where coming to the court for the court supervision is critical. The court is going to order the Sedeke trust. Again, I'm going to show you in Gibson's book where it actually says the word Sedeke trust. The modern equivalent of the word beneficiary is Sedeke trust or Sedeke trust, or however you want to pronounce it. However you want to pronounce it, doesn't really matter. But again, the Sedeke trusts that are making application to court, one of them, Clifford Trust, this is a Sedeke trust. Levy Trust, this is another Sedeke trust. And I'll show you some of the paragraphs that I'm working with that literally say the present right of the Sedeke trust coming forward is entitled to this, and this. And it's a whole bunch of good stuff. There's nothing bad in it. So the moment you put up your hand and say, I wish to come forward as a Sedeke trust, capitalize on the problem and fix the situation. And now let's settle the accounts. Let's get that credited into the securities account. Then you get a court order from the judge sitting in equity that literally says, Tony, or the beneficiary, or the Sedeke trust of Tony's life estate or Tony's equitable trust is hereby ordered, adjudged, declared, and decreed. Once you have a court order declaring the rights of the parties, this is what defines or establishes your capacity moving forward. We can put up your hand all we want, say, hey, I'm entitled, I'm in my capacity, but until you have a judge that agrees and stamps it with a court seal, I'm going to suggest we're not. We might be this close, but until you have an order from the court, we don't have that full power and full equitable right to be doing what it is we're talking about.
It was one of the changes we made on our Form 1, our Notice of Civil Claim. We were telling individuals in class to come in as the creditor knew them to be. You're going to notice that was amended. We made that additional note on our Telegram channel that we are changing it so that you're coming in as the trust. So the sheriff was coming after you or the creditor, and now we're taking that claim and switching it so that you're coming in as the defendant and you're coming in as the trust.
Remember, once you assert or claim that a trust has been created, the court is bound. They have to investigate. They have to ask some questions. They have to say, oh, okay, if there's a trust, who's the settler? Okay, who's the trustee? Okay, was there valuable consideration involved? Is there any trust property identified? What are the other terms and conditions of this trust? So you can see how you're going to need to be able to have some of these answers on standby. And the court is definitely going to be asking you some of these things. And again, if you can actually answer those 3 or 4 or 5 elements, watch what happens now. You are literally in the temple. you have your hand in that tabernacle box. You are of that elevated ascended position. But again, if you don't dispose of that interest, you don't have an equitable claim at all. Why? Because the record shows you're still possessed of the security interest. So until we deal with that, we're not truly entitled to equitable anything just yet.
And so with that, loved ones, this now concludes equity class number 6. Reason being, in 10 minutes, we are having our very first trusted life training program with our subclass members. We're now preparing them for court. We're going through the different forms, teaching them how to look up legislation and what those forms mean. We actually have a couple who got a babysitter for their little one so they can have a little date time with Divergence and be able to concentrate. So in respect of that and our subclass members, we are going to be diverting over to that class. In the meantime, though, please watch this episode, write down any questions that you have, put them on our chat. I'll include the new channels on our write-up as well so that you have that. And we will see you next Saturday. Bye, loved ones.
Hey, loved ones.